Welcome to a special edition of Immigration Uncovered, the DocketWise video podcast. I'm your host, James Pittman, and today we're diving into the headlines, delivering you an October and November immigration news roundup. We begin with state legislation in Texas, where we're covering significant developments that have far-reaching implications. Recently, the Texas House of Representatives made headlines as it passed 3 bills after hours of heated debate. These are Senate Bill 4, House Bill 6, and House Bill 4. While the state Senate gears up to review House Bill 6 and House Bill 4, Governor Greg Abbott is expected to sign Senate Bill 4, and that adds weight to these decisions. Let's go through these one by one. House Bill 6 is a bill allocating another $1.5 billion for Texas state border fencing and walls, and it raises questions about the efficacy in addressing immigration challenges at the U.S.-Mexico border. Senate Bill 4 takes a stricter stance, increasing criminal penalties for smuggling of persons. However, it primarily targets often unknowing, low-level participants, which raises concerns about its impact on actual crime deterrence and its lack of detail for support for trafficking victims. The bill that deserves particular scrutiny is House Bill 4. This is a highly controversial piece of legislation which triggers a multitude of concerns. It directly undermines and short-circuits the asylum process, in addition to which it disregards the implications on foreign relations, and it promotes Texas's unwelcome interference in federal immigration enforcement. The most alarming aspect of House Bill 4 is its potential impact on people's lives as it spreads fear within immigrant communities, which affects all state residents. The bill could possibly be unconstitutional and to some seems rather lawless, eroding fundamental protections like habeas corpus and due process. What the bill does is enact new criminal law in Texas that defines as crimes, quote, illegal entry and, quote, illegal reentry, but the enforcement of the law against which lacks the usual legal safeguards. House Bill 4 passed 83-63 after tensions flared in the legislature, which led to a temporary halt to action on the chamber floor. The vote finally took place at around 4 a.m., and the bill, which was authored by State Representative David Spiller, makes unauthorized entry across the border into Texas a Class B misdemeanor. That offense could increase to a state felony for any individual who was previously removed under the law. However, instead of arresting a migrant, a Texas state or local law enforcement officer could instead choose to order them to return to Mexico. If the person fails to comply, they could then be charged with a second-degree felony, which carries prison time of 2 to 20 years. Under the terms of this law, a migrant could be arrested at any time and anywhere in the state after they enter illegally. This amounts to a short-circuiting of the entire EOIR immigration court system, as the alien would be forced by state or local police officers acting under state law to self-deport by crossing the border from Texas back to Mexico. There would be none of the usual due process associated with removal proceedings as they are currently conducted in the Department of Justice, EOIR. Importantly, the House bill also requires local governments to indemnify local officials and police for claims for damages arising out of their actions taken to enforce these new code sections, unless the police or local officials have acted either in bad faith or with conscious indifference or recklessly. Note that local governments would be required even to indemnify ultra-vires actions which were taken in good faith. This legislation, according to immigration advocates, introduces a lawless reign of terror across Texas, jeopardizing communities. House Bill 4's basis rests on a misunderstanding of the complexities of the American immigration system. Immigrants contribute significantly to the U.S. economy, sustaining programs and enriching our society. Rather than facilitating humane and orderly entry, bills like House Bill 4 intensify chaos existing at the border. We must recognize that immigrants seek the U.S. for safety and opportunity, reinforcing our nation's values. Our response should be compassionate, organized, and respectful of human welfare. While there's still hope that House Bill 4 won't become law, it's essential to prepare for any outcome. Learning one's rights and advocating for legislative solutions is crucial. We need to invest in service providers and community organizations who are ready to address potential harms caused by such legislation. By advocating for a compassionate immigration system, we can create a lasting impact. Let's remember that laws like House Bill 4 are not our only option. Together, we can persist in demanding genuine solutions to the problems of orderly migration. Next, we're going to be talking about the Biden executive order on artificial intelligence and its immigration provisions. Just the other day, President Biden issued a groundbreaking executive order, which was aimed at ensuring that the United States takes the lead in harnessing the potential and addressing the challenges of artificial intelligence, or AI. This executive order sets new standards for AI safety and security. It emphasizes privacy protections, it promotes equity and civil rights, and it advocates for consumers and workers, encouraging innovation and competition, which will bolster American leadership on the global stage. Some of the key points of the executive order are, first, new standards for AI safety and security. Developers of powerful AI systems must share safety test results and critical information with the U.S. government. Strict standards, tests, and AI safety boards will ensure that AI systems are safe, secure, and trustworthy. Secondly, the order protects against misuse of AI in biological synthesis. The order establishes strong new standards for using AI in biological synthesis, which screen to guard against the misuse of AI in engineering dangerous biological materials. Thirdly, AI-enabled content fraud protections. The order has guidelines and mandates best practices to be developed for detecting AI-generated content and for authenticating official content. This ensures transparency and authenticity in government communications and prevents fraud. Fourth, Advanced Cybersecurity Program. A program focused on developing AI tools to discover and fix vulnerabilities in critical software will be established to enhance cybersecurity. Next is National Security Memorandum. A memorandum will be developed to ensure the military and intelligence community's safe and ethical use of AI. Sixth is Protecting Americans' Privacy. Congress is urged to pass bipartisan data privacy legislation to safeguard Americans' privacy, especially that of children. Federal support will be directed to develop and promote privacy-preserving techniques when using AI. Seventh is Advancing Equity and Civil Rights. The executive order addresses algorithmic discrimination by providing clear guidance to prevent discrimination and ensure fairness in the criminal justice system, and promote equity in various sectors. Eighth is standing up for consumers, patients, and students. Measures will be taken to ensure that the responsible use of AI is promoted in healthcare, education, and product safety. 9 is supporting workers. Principles and best practices will be developed to protect workers' rights and mitigate AI-related risks in the workplace. Number 10, promoting innovation and competition also involves the immigration aspect. Initiatives will be launched to catalyze AI research, promote a fair AI ecosystem, and expand the ability of highly skilled immigrants to study, stay, and work in the U.S. Number 11, advancing American leadership abroad. Collaborative efforts with other nations will be intensified to support the responsible use of AI and the development of international AI frameworks. And 12th and finally, responsible government use of AI. The order will ensure that the government's deployment of AI is responsible and modernizes the federal AI infrastructure. This comprehensive executive order reflects the commitment of the Biden and Harris administration to responsible AI innovation. It sets the stage for further cooperation with Congress and international partners to ensure that the U.S. remains at the forefront of AI development. Now that we've gone through some of the key provisions of the order, let's talk in particular about Section 5.1, which holds great importance for immigration lawyers and their clients. Section 5.1 aims to allow AI companies to attract global talent, especially technical experts, to the United States. This is a move that not only promotes innovation, but also shows that immigration pathways should be modified to attract and bring top talent to the U.S. to fill openings for those who specialize in critical and emerging technologies. Immigration lawyers in particular will find this section to be of immense interest as it directly impacts your work and the future of the clients you represent. So let's explore the key points of Section 5.1 and their implications in the context of immigration law and why it matters for both experts in AI and the immigration legal professionals who assist them. Section 5.1 is attracting AI talent to the United States. And the objective is to focus on attracting and retaining AI and emerging technology talent in the United States. One of the provisions is streamlining of visa processing. Within 90 days of this executive order, the Secretary of State and the Secretary of Homeland Security are tasked with streamlining visa processing for non-citizens traveling to the U.S. for AI and emerging technology work, study, or research. This includes making timely visa appointments available and maintaining a sufficient volume of available visa appointment openings. Section B highlights criteria for designating countries and skills. So within 120 days of this executive order, the Secretary of State is mandated to consider initiating rulemaking to establish new criteria for designating countries and skills relating to the 2-year foreign residence requirements for specific J-1 non-immigrants, especially those who have skills critical to the U.S. The department will also explore updates to the 2009 revised exchange visitor skills list and consider a domestic renewal program for J-1 visa holders. Next is expanding the visa renewal categories. Within 180 days of this order, the State Department is to consider rulemaking to expand the non-immigrant visa categories that are eligible for domestic visa renewals, potentially including academic J-1 research scholars and F-1 students who are in STEM fields, which are science, technology, engineering, and mathematics. Additionally, they will establish a program to attract top AI talent and emerging technology talent globally and connect them with educational employment opportunities in the United States. Next is modernizing immigration pathways. So within 180 days of this order, the Department of Homeland Security is supposed to review and make necessary policy changes to clarify and modify the immigration pathways for AI and emerging technology experts. And this will include changes to the O1A non-immigrant category, as well as the EB1 and EB2 immigrant categories, as well as modernizing the H-1B program. The department may also consider rulemaking to enhance the process for non-citizens to adjust status to permanent resident. Requests for information on occupation. So within 45 days of this order, the Secretary of Labor should publish a request for information, an RFI, to gather public input on AI and STEM-related occupations facing a shortage of qualified U.S. workers. So if you are interested in that, you should watch announcements by the Department of Labor for their forthcoming RFI and make your input on AI and STEM-related occupations known. There are discretionary authorities created by this executive order. The Secretary of State and the Secretary of Homeland Security are encouraged to use their discretionary authorities to attract foreign nationals with special skills in AI and emerging technologies to the U.S. Also, informational resources are discussed. Within 120 days of this order, the Secretary of Homeland Security will develop and publish informational resources to attract and retain AI and emerging technology experts. This includes a comprehensive guide and a public report on their utilization in the U.S. immigration system. In essence, this section of the executive order, Section 5.1, is designed to streamline the immigration process for artificial intelligence and emerging technology experts. It's designed to attract global talent and to ensure that the U.S. remains a hub of innovation in these fields. Well, that is your October-November Immigration News Roundup. Join us again for our next episode of Immigration Uncovered.